Hi, Intro to Law class. Today we're going to continue on with our lectures. Again, I apologize for having to provide you with all this material this way because this is really interesting stuff and it's a lot of fun to interact with this, but obviously we can't do that due to the realities of our society right now. And by the way, within that context, I'm kind of sad to report that a friend of mine, Judge D'Onofrio in Youngstown, died last week of the coronavirus. So it has now hit me directly and personally. So guys, be safe out there. All right, so today what we want to do is continue on with our topic. And by the way, you'll be getting some information about the chapters that are going to be on this last exam. And what I've done is I've eliminated about 3 chapters. So just follow what I've required you to read, and the format of the final exam is just going to be a number of identifications. And plus we're probably going to do this for the weekend, so that you don't have to worry about it during the week in case some of you are doing some jobs. If there is a problem with the dates that I provided you, let me know immediately. Hopefully there's no problems. And, unless it's something really significant, let's try and make it the dates that I've indicated. So let's continue on. So probably the last topic we're going to talk about in this class is this topic of family law. And in talking about family law, we're going to talk about 4 major issues. First of all, what is family law? And we're going to define it. Then, what do we mean by marriage? What do we mean by prenuptial agreements? And what is termination of marriage? And what are the implications of termination of marriage in regard to property rights, parental rights, and those types of things? All right, so let's talk about this whole issue of family law. Family law has been defined as generally involving all laws governing the family, such as marriage or a marital contract, parental responsibilities, termination of marriage, and you can terminate marriage in a number of ways, as we're going to talk about divorce, annulment. Then what happens upon termination of marriage in regard to notions of alimony, property division, child support, and child custody. Now, when we talk about family law, one of the things that we have to understand is family law is about protecting the family unit, especially the children. When we talk about family law, the other thing we have to know is that family law is governed for the most part by state laws. State laws. So the laws defining marriage, the mechanics of divorce, and the basic division of family assets upon divorce are all set forth in detail in state statute. So let's start talking about the major components of family law. And the first thing we're going to talk about in regard to the major components of family law is this whole idea of marriage. Marriage. And marriage is a very significant institution. And it's very significant for lots of reasons. I mean, obviously it's an important bonding of two different people, but it's also significant in that it's a very important legal status that has very important impacts on the people who engage in the marriage. So we want to talk about that. And therefore we also want to understand what it takes to enter into a marital contract. Now, first of all, the way traditionally marriages worked in our society is first you have a proposal of marriage, an engagement to marry. And a lot of people ask, does an engagement to marry, does that impose any obligations and responsibilities when you say to someone, will you marry me? And the asking of that question can have significant financial implications for the parties involved. So for example, if you look at page 603 of your book, they give you one of these legal focus problems. And it says, Sharon Wildley, an attorney, sues her fiancé, Richard Springs, for damages for ending their 7-week engagement, which had followed a whirlwind romance. She sued in federal court on the basis of diversity of citizenship. Sharon claims she suffered depression and lost income by giving up her main client. Richard told Sharon that she could keep the $19,000 engagement ring and offered her $10,000 to help her get through these times. She was divorced 3 times and had 4 children. Richard was once divorced and had fathered 3 children of his own. At the close of the trial, Sharon's attorney asked the jury for damages of $365,000. What's the result? Well, in this particular case, and again, this is a real case, it says the federal court awarded Sharon $93,000 for pain and suffering, $60,000 for lost income, and $25,000 for counseling. The case was exceptional because few states permit legal action seeking damage for breach of promise to marry on the general grounds that, quote, pillow talk cases should not be resolved in court. So in looking at this case, what I want to point out is this case is really an exception to the rule. In most states, the whole idea of engagement to marry and asking someone, will you marry me, imposes no financial duties or liabilities on the parties. So don't spend too much money when someone asks you to marry them, okay? Wait till you're sure that that is going to occur. Well, let's get to marriage. So someone asks you to marry them, then you get married. Now, as I said, marriage is an important legal status. And let's define it. Marriage is a status where you have the legal union of 2 spouses, and traditionally in most states they had defined that just as husband and wife, entered into by means of a contract that is enforceable by the courts. So let me go over that definition again. It says marriage is a status. It is the legal union of 2 spouses. In most states, traditionally it was the husband and wife, entered into by means of a contract that is enforceable by the courts. So think about what this then means. Marriage, by definition, grants rights to the parties and also imposes duties or obligations on the parties. Now, what these duties and obligations are can vary from state to state. But what we have to understand is that lawful marriage is a civil contract. It's a civil contract between 3 parties. The 2 spouses, and again, if you go with the traditional definition, the husband and the wife, and the state. The states define requirements for marriage of spouses. So in Ohio, we have Ohio Revised Code 3101, and you don't have to know this, but it defined marriage requirements as the following. For males, 18 years of age. For females, 16 years of age. The individual that you're marrying can be no closer than the second cousin, unless you live in West Virginia, and I'm kidding again, I'm just saying that. And there can be no other spouse. No other spouse. Now, when does this notion of marital status kick in? So the book talks about this on page 604. Again, it gives a legal focus problem. And it says, Alexis McVeigh and Martin Niedenhausen were exchanging wedding vows when Niedenhausen collapses. He dies of cardiac arrest in the ambulance. During their courtship, neither prepared a last will. Does McVeigh have any legal rights to inherit from Niedenhausen? And the book says very simply, McVeigh has no rights of inheritance unless their vows were completed and their marriage proclaimed. The law treats McVeigh and Niedenhausen just as it does any other unmarried persons. So no rights. The marital ceremony must be completed. The vows exchange before you enter into this legal status of marriage. All right. The other controversy that we've had in our society for like the last 20, 30 years has been the whole idea of same-sex marriage. Traditionally, up until about 20 years ago, state laws have restricted marriage to a man and a woman. And the question of what a marriage is or should be within this context is considered pretty controversial. But it is now established fundamental law. So can you have a marriage between two individuals of the same sex? And the Supreme Court has entered into this and has decided this once and for all for us. And the question, they said, is whether or not the right to marry is considered a fundamental constitutional right. And this is the case of Obergefell versus Hodges. And let me read what the court said here. Case was decided June 26, 2015, and the case overturns all state laws that would not issue marriage license to same-sex couples and would not recognize same-sex marriages. So the case legalized same-sex marriage throughout the United States and its possessions and its territories. The court examined the nature of fundamental rights guaranteed to all by the Constitution. And it indicated that the marital contract was a fundamental right protected by all. Prior to Obergefell, 36 states, including the District of Columbia and Guam, already allowed the issuance of marriage license to same-sex couples. So what it did is it forbade the remaining states from not allowing same-sex marriage unions. And by the way, this case came out of Ohio, because Ohio had passed a constitutional amendment through a referendum that defined marriage as only between a man and a woman. And it was called the Defense of Marriage Act. Well, it's this case, Obergefell versus Hodges, which overturned any application of Defense of Marriage Acts in the United States. All right, so that's a little bit about who can get married and what some of the requirements for marriage are. The next question we want to ask is, once you're married, what do I mean by this whole idea that it's between three parties, the two spouses in the state? And I said that within this context, marriage imposes duty and obligations. And just to give you an example, and again it varies from state to state, but let's look at the Ohio Revised Code, again 3103.01. And it says, in Ohio, there is an obligation of support. It says there's an obligation of mutual respect, fidelity, and support. So when my wife gets mad at me, starts screaming at me because I do something stupid, I always read her Ohio Revised Code 3103 saying, hey, you got to respect me, to which she scoffs and laughs. So this mutual obligation of support, according to the law, includes providing food, clothing, and working. So how far does this extend? Well, again, let's look at the book, and let's look at the legal focus problem on the bottom of page 610. And it says, Robert Hamilton became disabled and could not work. His wife, Sally, a trained legal secretary, had been serving as housewife and homemaker. Sally declared that she would not seek gainful employment to support her husband and would henceforth terminate the marriage. Is Sally required to go to work to support Robert if the marriage remains intact? What if the marriage is terminated? So the answer they provide is yes. Yes, Sally will be required to apply her earning skills to support her husband whether or not the marriage remains intact. So as you can see, that when I say that the marital contract is significant and it applies obligations and support, these are significant obligations and support. So before you enter into marriage, you better make sure you're serious about this. All right. Now there are other forms of marriage. So one of the forms of marriage that we can also talk about is something referred to as common law marriage. And by the way, this whole idea of marriage is a very tricky concept, and some people have invested lots of time trying to figure out how to beat the system. And probably my favorite example of this is Mick Jagger. Now, I don't know how much you guys know about Mick Jagger. Obviously, he's the lead singer of the Rolling Stones. But Mick Jagger, in reality, is an incredibly bright person. As a matter of fact, when he was a young man, he was admitted into the London School of Economics, which is considered the most prestigious school of economics in the entire world. So he's a bright guy. He's also, because of a successful rock band career, incredibly wealthy. So it's been estimated that he's worth about $1 billion. Well, Mick Jagger also likes to have fun and party. And he likes nice-looking women. So he's constantly dating, even when he's been married, women. So he had a couple of marriages. They were unsuccessful. And he had to make significant, huge settlements. And this was even before they were at the height of their popularity. So then he became a little bit more cautious. And what did he do? Well, he fell in love, or lust, whatever it might be, with a model from Texas. And her name was Jerry Hall, beautiful woman. And she says, Mick, I'm not going to hang out with you anymore unless we get married. So Mick's thinking this through. And he goes, okay, we'll get married, because he liked hanging out with her, if that's what you want to call it. So he arranges for a marriage ceremony in a small Caribbean island. And they get married, supposedly. Well then, Mick, true to his nature, starts dating Italian models, Brazilian models, fathering children out of wedlock with them, and this totally pisses off Jerry Hall, and she files for divorce. So Mick shows up at the attorney's office and says, oh, by the way, Jerry, we don't even have a valid marriage. She says, what are you talking about? He goes, oh, that Caribbean island doesn't recognize marriage for people who are not natives. Oops, we're not married. So therefore, you're not entitled, like you would have been under Texas law, to half of everything I own. So I'll tell you what, I'll give you a couple of million, but then get lost. And if you take me to court, you'll probably lose. That Mick, smart dude. So that's what he did. Now, on the other hand, you got a guy like Paul McCartney. All you need is love, and she loves you, and all the nice love things, rather than sympathy for the devil. And he's married to Linda McCartney for over 35 years. She dies. He's in mourning. But then he falls in love with a woman named Heather Mills, who was an ex-model. He marries her, and he marries her the right way. After about a year and a half, she says, I don't like Paul McCartney. He's a pothead, like she didn't know that beforehand somehow. He's also worth well over $1 billion. They file for divorce, and she gets half of everything that he has because he wasn't as tricky as Mick Jagger. He should have consulted with Mick. And because he didn't have a prenuptial agreement. So for a year and a half of marriage, she gets hundreds of millions of dollars. Not a bad deal. All right, well, we're going to get back to that. So we talked about marriage. There's also a concept that we refer to as common law marriage. Common law marriage. Now, what the heck is common law marriage? Some states recognize common law marriage. And what a common law marriage is when two spouses live together as husband and wife with no ceremony or certificate. By 2010, according to your book on page 605, only 9 states recognized the idea of common law marriage. Alabama, Colorado, Iowa, Kansas, Montana, Rhode Island, South Carolina, Texas, Utah, etc. But every state is pretty specific about what it is you need to have a common law marriage. For a common law marriage to exist, the parties must be legally qualified to marry, which means they're single, they're of the appropriate age, and they have the required mental state. So in other words, they can't be insane. Now, the burden of establishing a common law marriage is on the party claiming its existence. So it must be proven by clear and convincing evidence that every element of the common law marriage exists. And what are these elements? Well, in every state that has common law marriage, they have 3 basic requirements. First, a mutual agreement to marry in presentia. Now, what does that mean, in presentia? It means that you are holding yourself out to be married now. Now. That this is my wife, and that's how you might introduce the person. So you can't say something like, one of these days I want to get married. Once you say that, it's not in presentia, and there cannot be common law marriage. Secondly, cohabitation as husband and wife for a certain period of time. So every state has different amount of years. 7 years is the way some states have it. Some states have it for less. And you must hold yourselves out to the community as married. This is my spouse. So, let's say we had a situation where Farrell, your boyfriend, says to you, hey, baby wavy, I really love you. And I'll tell you what, I just got accepted to the medical program in Texas, and I know you want to be a lawyer, but come with me in Texas, cook for me, let's party together, let's have fun, and then when I get my medical degree, I'll take care of you and you can go back to law school. So you say, "Aw, how nice. My baby cares about me." So you go with the person. And for 4 years through their medical school curriculum, you support them, you work side jobs, you help them, you buy the food, you pay for the apartment. And after 4 years, he finally gets his degree. And medical doctors, because he's a surgeon and he has a specialty of brain surgery, is making hundreds of thousands of dollars right off the bat. So he's probably making $500,000-$600,000, and he decides he wants to buy himself a Corvette. And now you're saying, "Hey, now it's my turn. Remember, you said you were going to send me to law school." Well, about that time, he meets a new baby who's a younger version of you, and says, "You know what? I want to break up with you, and don't let the door hit your butt on the way out." What can you get? Well, the answer to that is there is no common law marriage, because he never said he wanted to be married now, and you would get nothing. So the next time someone says, "Hey, baby, I want to marry you someday. Will you come down to Texas with me?" You say, "Let's get married, put a ring on my finger, and then I'll talk about going to Texas." That's the way it works. Okay. The point is if you live together without the formality of traditional marriage, the courts have generally not provided any protection to either party. And in a brutal assessment, and it's presented to you, I think it's on page 606 of Michelle Travola and Lee Marvin, the court says there is no contract based upon the exchange of, quote, "sexual favors." So, if you don't want to be taken advantage of, you better get married. And by the way, understand that marriage imposes a mutual obligation. An obligation on the other party and the obligation upon you. All right. The next concept we want to talk about in regard to this whole idea of this marital agreement and the responsibilities it imposes is the idea of a prenuptial agreement. A prenuptial agreement. Now, the book also talks about it as premarital agreement or an antinuptial agreement. Any one of those terms pretty much means the same exact thing. What is a prenup? A prenup is a marital contract made before marriage. So a prenup is a private contract where two parties who are contemplating marriage specify certain future mutual rights and obligations in case there is a termination of the marriage. Now think about this. I personally didn't write prenups, but one of the people in my law firm had an office right next to me and maybe witnessed some of these things, and to me they're pretty amazing. You'd have this, and generally it was an older guy, in his 50s and 60s, who was balding, but worth millions of dollars, coming in with this beautiful young woman, and he would be telling in the prenup that even though he was worth $100 million, on termination of the marriage, she wouldn't get anything more than, say, $1 million, and that's it. And as part of this agreement, the attorney always had to explain to both parties, and the husband obviously understood this, look, understand that if you sign this, this is going to be applied, and this has to be a knowing and waiver of your rights. And generally these young women would say things like, oh, he loves me, he'll never leave me. And, as I said, I witnessed a couple of these. And of the 4 or 5 I witnessed within about 2 years, most of them were divorced. So take prenuptials very seriously. And as I said, a prenuptial generally establishes property division and support payments if and when the marriage ends in divorce. Now, all states recognize prenuptial agreements, and almost half of them have adopted some version of the Uniform Premarital Agreement Act, which was the model code written by the American Bar Association. And they say that these prenups can deal with things like 1, property and support rights during and after marriage; 2, personal rights and obligations of the spouses during marriage. So, for example, Donald Trump actually has a prenup with Melania, and as one of the parts of the agreement, she cannot gain more than 5 pounds. That's kind of an interesting clause to have in your marital contract, huh? It gets them off on a lot of expensive dinners, I guess. And it also has clauses that can deal with education, caring, and raising of children, property division, and support rights. So again, if you want an example of this, in your book on page 644, they give you an example of Barry Bonds. Barry Bonds was like one of the all-time home run leaders in baseball, a multi-millionaire worth hundreds of millions of dollars. And here's the scenario, again, a real-life scenario. It says she met him in Montreal in the summer of 1987. The meeting led to telephone calls and a fall visit, and a later move to his Phoenix home before marriage in February of 1988. The day before the Las Vegas marriage, both signed a premarital agreement stating in part that all the earnings and accumulations resulting from the other's personal services, skills, efforts, and work, together with all the property acquired with funds and income derived therefrom, shall be the separate property of that spouse. So basically what Barry Bonds is telling this woman is what's mine is mine and what's mine is mine, and you can have whatever you earn, which next to nothing. So in the property settlement portion of the dissolution action against Barry Bonds, Susan Sun Bonds, she called herself, sought to have the agreement set aside, arguing it was unfair and that she did not understand it when she signed it, and she was not represented by counsel at the time. And the book somewhat facetiously asks, was her argument a home run?